welcome to the Republican Professor. This afternoon on Good Friday, we have a special guest, Ralph Rossum. Thank you for joining us, Ralph.
I'm so happy to be on your podcast, Lucas.
I'm happy you're on too. We brought Professor Rossum on today to talk about his book, Federalism, the Supreme Court, and the 17th Amendment. The subtitle is The Irony of Constitutional Democracy. And it's published by Lexington Books. And I've been going through this for quite a while. And I got to tell you, it really made me rethink my love of some Supreme Court decisions. And, I thought, why not just have you come on if you're willing to and tell us the story behind the book? How did you come up with this topic for this book?
Well, it's an interesting story. I was sitting in my office in March of 1987, and I got a phone call from John Baker, a law professor at LSU, and he explained that LSU is in Louisiana, and Louisiana is a civil law state. Not only is the common law practice, but a European civil law of the Code Napoleon, and that they thought it would be important for their students, if they wanted, to have a chance to study over a summer in a real civil law country. And they chose Aix-en-Provence. It's one of the most beautiful cities on earth. It's in the south of France. And they had established this program where in the summer, they would bring over a Supreme Court justice after the court's term concluded, so starting in early July, and for a month, have that Supreme Court justice teach LSU students who came over from the United States, and the students would also take real French civil law courses as well. And so he's explaining this to me, and I'm figuring out, why is he telling me all of this? And he says that they had invited Justice Scalia. Scalia was appointed to the court, confirmed, and began serving in October of '86. And so it's now near the end of Scalia's first term on the court. And they approached him and they said, it's the bicentennial year. You have often cited the Federalists in your academic writings and as a judge on the DC Circuit. And would you be willing to teach a course on the American founding? And he said, well, I know the Federalist well, but I have to admit, I've never read the records of the Federal Convention. And I had written fairly extensively on the records of the Federal Convention. And that's why they approached me and they said, would you like to teach a course in the American founding with Justice Scalia?
Wow. Wow.
Yeah.
How cool, how cool is that?
You can imagine how little time it took me to say yes to that. Now, LSU was paying a fairly lavish honorarium for Scalia to come and put him up in a really fine place. And Maureen, his wife, was there as well. And they didn't offer me an honorarium, but I was director of the Salvatori Center, so I had a summer stipend in any case, but they covered all of our travel expenses for the whole family and put us up in a wonderful apartment just 1 block away from the Cour Mirabeau, one of the most famous streets in Aix. And my day began with getting up at about 8 o'clock, having a nice breakfast, spending an hour and a half, two, preparing for class, taking a quick shower and shave, and walking 10 minutes to the law school.
Wow.
And teaching with Scalia from 11 to 1. And we did that Monday through Thursday. I'd come back at 1 o'clock.
Wow.
My wife would have prepared a wonderful luncheon, fresh food out of the local markets. And like
Wow.
at 2 o'clock, we'd get in the car and we would explore Provence and get back at like 10 at night and then get up the next day and do it all over again.
Wow.
And it was a glorious month. Well, so I thought, here is Scalia, who hasn't read the records. Here's my chance to teach him the records. And so the first part of the course was going through the records of the Federal Convention of 1787, Max Farren's 4-volume work. The 2 volumes that really immediately have James Madison's notes and others who wrote notes concerning what was going on day to day. And I'll do this in parentheses. I expected that Scalia would then start citing the records, and he never did. And I thought, boy, did I fail as a teacher of the records, that Scalia never used them. But when I started working on my book on Scalia, I realized Scalia totally rejects what's called legislative history.
Mm-hmm.
He wants, upon his death, William Eskridge, a Yale law prof, said, for Scalia, you might say, to sum up his approach, it's the text, the whole text, and nothing but the text.
Yeah.
And so Scalia wasn't interested in how it was formed. He was only interested in what the actual words were. And so when I came to understand Scalia's approach, I understood why he never cited the records, because they were so much legislative history in his mind. And well, anyway, going back to
that makes sense.
Going back to the in-class the in-class experience with him, he had been a law prof at University of Virginia, then U of Chicago, and I had no hesitation about interrupting him in mid-sentence when he was making various claims. It was just a lot of fun. And anyway, it set in motion a friendship with Scalia. When I was at CMC, whenever I would be going to Washington, D.C., I would call his chambers and see if he was available to go out for lunch. And he often was.
Oh, wow, that's cool.
We would climb in one of the Supreme Court limos and be taken to his favorite restaurant.
Was there a security detail?
No, it was the two of us.
Really?
And, yeah.
Just the driver and you?
Yeah. And
Wow.
actually, at one of the restaurants, Scalia and I were having lunch in one booth, and Rehnquist was having lunch in the next booth, and there was no security detail whatsoever.
What year was that, do you think?
That would have been the late 80s.
Wow. Different
early
time.
90s. Yeah. So
that's surprising to me, especially after what happened with Reagan in 81.
Yeah. Well, but anyway, I would buy the wine, and we would chat, and basically I would go home afterward and write down what transpired in the conversation and treated it basically as an interview. And so maybe a little more on Scalia before we get back to the 17th Amendment.
Please. The more Scalia, the better. Hey, this is great.
Well, so one time I was going to DC, and I called his chambers and I said, can we have lunch? It was a Friday. And he said, I have to go to a memorial service at noon, but why don't you come by my chambers at 3 in the afternoon? And so I did. And this is right after my book on Scalia had come out. And I was waiting in the marshal's office to be escorted back to his chambers. And the secretary, whatever, in his chambers came to retrieve me. And as she was walking back, she said, "I'm really new at the job. I've only been here 2 weeks. And my first assignment was to read your book."
Oh, wow.
Yeah, so
That's
Scalia
a high
offered,
compliment.
yeah,
That's a very high compliment.
yeah. And so I'm in Scalia's chambers, and partly I'm there because CMC wanted to invite him to come and give a talk on campus. Claremont McKenna College has something called the Res Publica Society. If you contribute at a certain level, you are a member of that society, and 2 or 3 times a year, you'll be invited to give you'll be invited to hear a major speaker at a convention hotel. There'll be 600-700 of those attending, and they're big names. And they said, Ralph, you were once dean of faculty. And when you were dean of faculty, Scalia came. And that was shortly after I had team taught with him. And they said, "What did he charge?" And he said, "I have no idea. I wasn't part of that negotiation." And they said, "We're prepared to offer him $40,000 for 2 talks, one on campus and one for the Res Publica Society. And we'll fly him and his wife first-class airfare, and we'll put them up in a really nice hotel." And so they had sent a letter to Scalia inviting him to come, but they didn't include any information about what they were willing to offer, because first of all, they didn't know whether he was able to receive an honorarium. And 2, they had no idea what it might be. And so I'm in his chambers, and I said, "Did you get the letter from Claremont McKenna?" And he said, "Yes." And I said, "Well, they're prepared to offer you," I thought 40,000 was outrageous. I said, "They're prepared to offer you 20,000 plus first-class airfare and this and that." And he thought for a moment, and he said, "I'll take half." Now, I think that may have been, his calculation was, they can only accept so much additional honorarium compensation per year. Now, that's not the case for book royalties. Scalia and Brian Garner, a law prof at, it's in Dallas, SMU Law School, wrote a book called "Making Your Case: The Art of Persuading Judges."
Yeah.
And one year, they have to report financial disclosures each year. And one year, Scalia's portion of the royalties for that book was $80,000.
Wow.
So the book is called "Making Your Case: The Art of Persuading Judges," and it's giving appellate written and oral advocates advice as to how to make your case, how to persuade judges. Scalia hates legislative history.
Yeah.
But in the book, he said, "Look, if you know you're appearing before a panel that uses it, you've got to give it to them." So my daughter-in-law is an associate with Jones Day, one of the biggest law firms in the country. She's in the Irvine office. And I had an extra copy of this book, and I gave it to her, or I tried to give it to her, and she said, "No, I already have it." Every partner and associate was given a copy of the book, which, well, says something about its impact. Well, when Scalia came to, I'm in his office, And he says, I'll take 10. And then he said, did you read my opinion in Rapanos? Rapanos against Environmental Protection Agency, EPA. No, Army Corps of Engineers, Army Corps of Engineers. And it was a case that had to deal with Rapanos, who had put some soil on a low spot 20 miles from the nearest river, but he was accused of polluting the navigable waterways of the United States and had imposed on him a huge fine. And he got his case before the Supreme Court, and Scalia was prepared to write the majority opinion when Anthony Kennedy went light. Anthony Kennedy agreed that what happened to Rapanos was impermissible, but he was unwilling to establish a hard and fast rule on the matter. And I said, no, I haven't read the opinion. That's a Commerce Clause case, and Alan Tarr, my con law co-author, is responsible for those cases. And he said, oh yeah, and he pointed up and he said, I've got your books right up here. And then he got on the phone and called to the outer office and said, print out a copy of Rapanos. And in it came, and he paged through and he found what he wanted. And it was where Kennedy was unwilling to give any firm guidance for the Army Corps of Engineers or for landowners as to what can or can't be done. And he dropped a footnote at that point concerning Kennedy's unwillingness to be conclusive. And the footnote was about an ancient Hindu priest who was talking to an acolyte and said, the world is supported on the back of a giant tiger that stands on the back of a giant elephant that stands on the back of a giant turtle. And the acolyte said, what does the turtle stand on? And nonplussed for a moment, the priest regains his composure and says, well, from then on, it's turtles all the way down. Scalia wanted me to hear that. Well, so anyway, going back to Scalia and the course in Aix on Provence. One day in class, this is spring of '87, summer of '87. That spring, the Supreme Court handed down South Dakota against Dole. And this was the case in which the court upheld Congress's power to withhold 5% of federal highway funds from all states that didn't raise the drinking age to 21. And remember, with the passage of the 26th Amendment lowering the voting age to 18, lots of states lowered the drinking age. You know, if you're old enough to be drafted at 18, you should be able to vote and you should be able to drink. Well, there was carnage on the highway in part as a result of that. So Congress did a kind of nudge. 5% was not considered by the court to be coercive, and Scalia joined the majority opinion by Rehnquist saying, this is constitutional. But then Scalia blurted out, I could not imagine that a pre-17th Amendment Senate would have agreed to this measure, because the senators were ambassadors of their states and they would have looked out for state interest. And the senators would have been apprehensive about standing for re-election, where they'd have to go back before the state legislature and explain to those who would vote either to return him or not why he had so little confidence in their in the state's judgments that it required federal control. And that hit me like a lightning bolt. I had never thought about the 17th Amendment for 1 minute.
How long had you been teaching at this time?
72 to 87, 25 years.
15 years?
Pardon?
15 years, 72 to 87? That'd be 15 years.
Okay, 15, yeah.
That's a long time not to think about the 17th Amendment. So you just had thought, what was your opinion about the 17th Amendment?
Well, just that, it put it in the hands of the citizenry to vote for senators as they voted for representatives. But I never thought about the kind of structural ramifications of that. And so over the next number of years, I was teaching annually a graduate class at Claremont Graduate University. And it was on national powers always. And a number of students were kind of celebrating the Supreme Court's invalidation of any number of FDR's New Deal initiatives. And I said, but of course, a pre-17th Amendment Senate would have never agreed to this vast expanse of federal power at the expense of the states. And that with the 17th Amendment having been ratified, the original constitutional design, the original federal design, was altered. And for the court to step in and now strike down these measures, this democratically elected Senate, having voted for them, is judicial activism at its worst. And so I made that argument for a number of years. And then in 1998, I got the opportunity to spend 6 months as a visiting fellow at the Liberty Fund in Indianapolis. The Pierre Goodrich, having nothing to do with the tire company, founded Liberty Fund. He was a graduate of Wabash College, an all-men's college with a strong liberal arts tradition. And Pierre Goodrich was able, they owned various mining interests. They owned the Indiana Telephone Company. They owned a number of banks. And Pierre Goodrich was prudent, shrewd, clairvoyant enough to see the oncoming Great Depression. And he took most of his businesses to cash and came out of the Depression with tons of money and made an absolute fortune and donated ultimately about $500 million to endow the Liberty Fund. And the Liberty Fund is not a grant-making foundation, it's an operating foundation. They do their own programming. And one of the things they do are all kinds of, well, they did for 15 years my week-long seminar for federal judges. We would have like 18 federal judges meeting in luxury resort places like Marriott's Casa Marina in Key West, or various places in the Copley Place Marriott in Boston, or well, great places. It was a week-long seminar. We were asking a judge for 2 weeks of their year, for 2% of their year. And so we wanted to do it in places where they would invite their spouses to come. And so we would have 18 federal judges and a panel of scholars taking them through the drafting and ratification of the Constitution, the Bill of Rights, and the 14th Amendment. And well, anyway, the Liberty Fund did that, and they also had a visiting fellow program. And so I spent 6 months. My only responsibility was to show up at the office from 8 to 5, wear a coat and tie, and then do whatever I wanted. And I decided that would be the perfect opportunity to see if I could really make that 17th Amendment argument work. And
Wow.
I ended up
Great idea.
writing a long law review article that the University of San Diego Law School published. And I then subsequently plumped that article up into this book. An interesting thing about the law review article. Susan Ehrlich was on the Court of Appeal in Arizona, and she had come to one of my, I'd attended another Liberty Fund seminar with her, and we became friends. She actually, when Sandra Day O'Connor got appointed to the Supreme Court, Susan Ehrlich was elected to the position that O'Connor vacated. And she loved to copy edit. And I sent her the law review draft. And she said, I don't like the ending, you've got to make it stronger. And she made all kinds of nice improvements. And so on May 15, 2000, the Supreme Court handed down Morrison against United States. And it dealt with the question of the constitutionality of a provision of VAWA, the Violence Against Women's Act. And the question was, where did Congress get the power to pass this? And there were two sources of power. One was the Commerce Clause, and the other was Section 5 of the 14th Amendment. And the Supreme Court found neither availing. And David Souter, Justice Souter, wrote a lengthy dissent, and I'm reading that dissent. And suddenly, something looks really familiar. And I went to the law review article, and Souter had basically lifted 4 pages right out of my law review article without citation.
Oh, wow.
And there were subtle changes. If I said Madison and Hamilton, it said Hamilton and Madison. So I did side by sides. I highlighted the passages and I showed it to some colleagues, and they said, oh, you've got to write a letter accusing Souter of being a plagiarist. And I said, I've been cited by the Canadian Supreme Court. I want to be cited by the US Supreme Court. I don't want to charge them with plagiarism. I want to be cited. And so I drafted a letter, and I called Susan Ehrlich, this judge in Arizona, and I read the side-by-sides, and she said, oh, you've got to write to Souter. And so I did. And so I read her, I said, listen to this. And I read her my letter, and she said, I don't like it. Email it to me and let me play with it. And so later in the afternoon, it came back, and it was softer in some respects because it said this was doubtless the mistake of a harried clerk at the end of a busy term. But it was also insistent that I be cited. And so I didn't alter a word. I printed it out, signed my name, and included in an envelope to Souter both the letter and the side-by-sides. And right at the end of the court's term, I get a letter from Souter saying, dear Professor Rossum, thank you for your letter, of course. And he said, you've made a very fine point, and I will make certain that there is a citation in the final version of the US reports. And then he went on and said, but there's a fine point to be made on the other side. He'd obviously now read the article. He said, you view me as a sinner in this case and that and the other. And he said, I don't know that I need to cite you because I don't agree with you. And then he
Wow,
went
that's
on in
weird.
the next paragraph to say, I have never really thought through the intellectual debt I owe to those people whose works I cite. Well, anyway, I tell the story to my students, and I say, listen, if any of you ever get in trouble with the Academic Affairs Committee for engaging in plagiarism, come to me and I can negotiate the sale of a copy of this letter. So you can cite a Supreme Court justice as saying, well, I didn't cite it because I didn't agree with it. Well, anyway, he did cite me in the final version.
Wow.
The 17th Amendment article becomes the book. And I was asked by the editor of something called The American Interest to do a brief piece on the 17th Amendment. And he entitled it, A Short History of a Big Mistake. and let me just mention something.
Sure.
Right before the Bill of Rights begins, right before the First Amendment,
Mm-hmm.
In the government printing office version of the US Constitution, they insert the following. Articles in addition to an amendment of the Constitution of the United States. Most amendments are additions to.
Right.
Like the Bill of Rights.
Yeah.
The 13th Amendment,
Mm-hmm.
15th Amendment. The 16th Amendment is a correction of judicial error in the 1895 case that I'm drawing a blank of right now, which struck down an income tax. The 19th Amendment was, well, the 18th Amendment obviously was an addition. The 19th, women's suffrage, the 20th, the 21st, the repeal of prohibition.
So you're saying that they don't go into the original text and add it there; they just tack it on at the end, and then you have to think about how it alters.
The 14th Amendment is actually an amendment of, because it gets rid of the 3/5 clause. It's a correction of judicial error because of the Dred Scott decision. And it's in addition to, because it gives us the privileges, immunities, it gives us everything else, privileges, immunity, everything in sections 1 through 5. The 12th Amendment is a real amendment because it alters the method of presidential election. It alters Article 2. This 17th Amendment is one of those few that is really an amendment of the Constitution. Because it takes us from election of the Senate by state legislatures to a direct election of the Senate. And so
yeah, I see what you're saying.
So when I started thinking about the 17th Amendment, the subtitle of the book, The Irony of Constitutional Democracy.
Yeah, that's an interesting subtitle.
And
caught my eye, that's for sure. The irony. Yeah.
Well, and so what happens? The original mode of protecting federalism was not an activist Supreme Court, but the mode of electing the Senate. Senators were understood to be ambassadors from their states.
Yes. Yeah.
Listen to this quotation from Alexander Hamilton. This is in the New York Ratifying Convention. When you take a view of all of the circumstances which have been recited, you will certainly see that the senators will constantly look up to the state governments with an eye of dependence and affection. If they are ambitious to continue in office, they will make every prudent arrangement for this purpose. And whatever may be their private sentiments or politics, they will be convinced that the surest means of obtaining re-election will be a uniform attachment to the interests of their several states. Not so much the initial election of the senator, but the political
Right.
ambition of being reelected
Right. Yeah.
will make certain that they are ambassadors of their states and that they will protect the interests of their state as a state, and ensure that federalism is thereby maintained, that the residuary and inviolable sovereignty of the states, as Federalist 39 describes it, is maintained.
Do you mind if I make a comment there?
Please.
There seem to be a lot of folks that make the case or seem to assume that the founding generation did not want professional politicians. And that quote that you just read there seems to imply and that that was kind of a virtue of the way they set it up, was that the senator would want to be reelected.
Yes.
And that would be a sufficient motivation to do a good job.
Remember Federalist 51, let ambition check ambition.
Yeah.
Yeah.
And
self-interest.
So
yes.
there's a popular misunderstanding, I think, going around. I think there's also a push to have term limits, and that would seem to undermine the original design, which was that the assumption is the reason they want to do a good job is to get reelected. They
Yes.
want to get reelected. That's a good thing.
Well,
I just wanted to make that point.
Yeah. Speaking of self-interest, I'll continue the digression.
Yeah.
Mercy Warren, who was the wife of James Warren and the sister of James Otis, wrote a 3-volume work. They were good friends. She was good friends of Abigail Adams and John Adams. And she wrote a 3-volume work entitled The History of the Rise, Progress, and Termination of the American Revolution.
This is a person named James Warren's wife?
Yes, Mercy Warren.
Mercy Warren, okay.
And in the book, she writes, Americans are too proud for monarchy, too poor for nobility, and it is to be feared, too selfish and avaricious for a virtuous republic. Isn't that a great statement? And the founders agreed, and the solution was self-interest.
Yeah.
Let ambition check ambition, and let the self-interest be a sentinel for the public good. Well, anyway. Yeah, and so.
But channel it, structure it in such a way that it's channeled for, well, the structure will counteract the worst elements.
Yeah.
But you have to have you have to have the ambition, or it doesn't work.
Exactly. And so for a while that tended to work out quite well. But then the democratic impulse begins to dominate. There was an 86-year campaign to alter the mode of electing the Senate. All of the early efforts were in the House of Representatives, where they would propose a constitutional amendment to alter how the Senate is elected. They went nowhere, and finally, right after the election of Woodrow Wilson, who had long coattails. There were sufficient number of senators elected, Democratic senators elected who supported this change, and they push it through. And the 17th Amendment, when it was ratified, was the second most shortest. It had the second shortest period of time to become ratified of all amendments to date. The 12th Amendment was ratified more quickly with regard to changing how the Electoral College operated. And so we had this push to put, they wanted democracy more than they wanted the original means of protecting federalism. And so the irony becomes, now that the original federal design has been changed, the court wants to step in and protect that original federal design by striking down laws that this new democratically elected Senate has helped pass. And so originally we had federalism protected both structurally, the mode of electing the Senate, and democratically, because the state legislatures were themselves democratically elected. But after the 17th Amendment, with an activist court, we have federalism now protected not by structure, but simply by an activist court invalidating actions of a democratically elected Senate. And so that's the irony. And
yes, it is the irony. That some people listening to this in the future might think, I think it's an odd, you're now you're a fan of Scalia, I think.
yes.
It must feel a little strange to be on the same side as Souter, which I think you were saying earlier. And Souter is now citing you. So is that politics makes strange bedfellows, I guess, but you're saying that you see what Souter was saying, or actually Souter saw what you were saying. He should have given you credit for it right away, but whereas I guess his clerk should have. But
so, you know, I had occasion to, over lunch with Scalia, say, especially in the state sovereign immunity cases, in the Constitution originally, in Article 3, Section 2, gave federal courts power to hear cases involving a state and a citizen of another state. In Chisholm against Georgia in 1793, the Supreme Court, 5 of the 6 justices, everybody back in the day wrote a separate opinion, concluded that Chisholm's suit against Georgia, he was from, I think, South Carolina, concerning lands that were seized from him during the Revolutionary War, that Chisholm had standing to sue. There was no understanding of state sovereign immunity. The ratchet turned both ways. A state could sue a citizen, but the citizen can sue a state. And James Wilson's opinion was perhaps the most persuasive in that respect. Well, this offended lots of state legislatures. They didn't want citizens of another state hauling them into federal court. So they urged, what's the phrase? They commanded their senators and requested their House of Representatives to adopt a constitutional amendment overturning Chisholm. And that passed really quickly. But
that's the 11th Amendment you're talking about?
Yeah. But what the 11th Amendment said was no diversity jurisdiction suits. You can't, a citizen of one state can't sue another state. But the Constitution itself says that the federal courts would have jurisdiction in all cases arising under the Constitution and the laws of the United States, and treaties made or which shall be made. And so that, quite apart from diversity jurisdiction, there's this arising under or subject matter jurisdiction. And the 11th Amendment doesn't address that at all. And yet the Supreme Court, in a whole series of cases that I recount in the book, acted as if the 11th Amendment barred not only diversity jurisdiction cases, but arising under cases as well. And when I was having lunch with Scalia, I would say, how can you as a textualist agree to an opinion by Rehnquist, which said, when it comes to the 11th Amendment, what matters are not the words, but the idea behind them. And so we would have a great debate on that. Yeah. I also have written a book on Clarence Thomas called Understanding Clarence Thomas, the Jurisprudence of Constitutional Restoration. And
wonderful book. I've read it.
On these state sovereign immunity cases, Thomas actually goes so far as to apply it not simply to federal courts, but to federal administrative agencies, the Federal Maritime Commission, which I criticize him in the book. It's totally it's hard for me to respect a textualist who departs so far from the text.
I see. That makes sense. There's a lot of detail in your 17th Amendment book, and the thought that some of our most treasured judges on the federal judges, justices on the Supreme Court, people that we come to think of as defending the Constitution, would miss something like that so obviously, especially the Commerce Clause cases. That's it was I think it was the Rehnquist court which was the first to try to put an outer limit on those on the Commerce Clause cases.
Lopez,
and that was not very long ago.
He admitted that the broad interpretation of the substantial effects test has taken us a long way toward basically giving the federal government police powers.
Yes.
He said, oh, we've taken too many steps, we're not going to take one more.
So you're saying that maybe somebody listening to this is barely hanging on here, but they're interested in what's going on here. In the case of Lopez, I thought it was actually a gun case. It wasn't a Second Amendment case, but it was related to guns and school zones, I believe. Is that right?
The Free School Zone Act.
Something like that. Yeah. So there was I think it was a federal law now that at the time, it was a federal law that was prohibiting firearm possession within a certain number of feet of a school or something.
There was
does that sound right? Under the Commerce Clause?
There was a massacre of young kids in, I believe, it wasn't Sacramento, but
Stockton?
Modesto, a Central Valley.
Might have been Are you talking about Stockton in 1989?
Stockton, yes.
Okay.
And
I remember that.
They obviously, California had a law against killing kids. But the feds, Congress had to step in and grandstand and show we are opposed to this as well.
Yes.
And that's the Guns Free School Zone Act that prohibited anyone from possessing a gun within 500 feet of a school. And that meant actually that
as a matter of federal law, not just state. Yeah.
And so actually, if it's the middle of the summer on a Sunday afternoon when no school is in session,
Yeah.
and between you and the school is a river, and you're on the other side of the river, and you have an unloaded shotgun in your pickup on the gun rack, you were subject to the punishments of having violated the Guns Free School Act. Well, anyway, Lopez brought a gun to school, and Texas had a law against it, and they initially brought suit against him under the state law. But because the federal punishment sanctions were more severe, it was transferred to federal court. And the Supreme Court said, how does simply possessing a gun in a state have a substantial impact on interstate commerce? And
yeah, that's the issue. Is
yeah,
what does it have to do with the Commerce Clause?
Yeah, said, this is
interstate commerce, not intrastate.
Yeah, this is extending the substantial effects test too far. And Breyer was one of the dissenters. And Breyer pointed out how actually this didn't have a substantial effect on interstate commerce. And he had like a 28-page appendix to his opinion with lots of articles, academic articles making his case. And he argued that if there are guns in school, kids get nervous. If they get nervous, they don't learn as much. If they don't learn as much, they're not going to get as good jobs. And if they don't have good jobs, they can't afford to buy goods in interstate commerce.
And that was his argument for saying this is solidly within the purview of the Commerce Clause.
Yes.
This legislation, this federal police power. Some people might not know what you mean by police power, but generally the idea of a police power was the states reserved a police power.
Yes. And the police power was
that was for health, welfare,
morals of the community. Yeah.
Yeah. That's the theory of having the police, right? That's what the police is justified on. Of course, there always has been a federal police power in a way because, well, for example, on military bases, there's military police, there's investigations of traditional criminal offenses like murder, stealing. Those are traditional police powers of the state to prosecute those things.
Violate federal law. And for a long time, violating federal law meant embezzlement or tax evasion or other things. It's only more recently that we have had the federalization.
Or on federal property, the traditional stuff on federal property. Yeah.
And we only recently had the federalization of criminal law with the huge increase in the number of offenses for which the FBI and other federal agencies have jurisdiction. Remember, once upon a time, all of drug offenses were state offenses only, not federal. Prior to the Controlled Substance Act.
That's right. That's right.
Yeah.
So you're saying that by changing the mode of election of the Senate, the U.S. Senate, which is what the 17th Amendment did. Originally, the state legislatures, they picked the senator by a vote, like a simple majority vote. Yes. Is that right? Okay. Yeah. So it was like passing a concurrent resolution or something in the state legislature. And then the senator would serve for 6 years ordinarily, unless they resigned or died. And the mode of election was changed because of a democratic impulse. Seemed like there was a movement in the 1800s toward a more democratic impulse, and part of that was the mode of election of the U.S. Senate to take that power out of the state legislature and put it directly in the hands of the people at the ballot box, the people of that state, so that the senators didn't view themselves so much as representing a state as the people. Does that sound fair to say?
Yes.
Okay.
and you might ask,
And
why?
that shift has huge implications.
And you might ask, why would state legislators vote
Yeah.
to ratify an amendment where they give up this power that they have to elect
That's
senators?
yeah.
And
Why would they do that?
what I report in the book
Yeah. Mhm.
is
You get,
legislative
it
deadlock.
removes the power from the state, right?
Yeah,
In the federal government.
it turns out that electing a senator became a very time-consuming and difficult matter. Remember when the Constitution was ratified, there wasn't an anticipation that there would be the development of political parties.
That's
And
true.
so what happens when the lower chamber of a state legislature is controlled by one party and the Senate by another? How do you elect a
Right.
senator in those circumstances where,
Mm.
and there were, I believe, if I recall correctly, 72 examples of legislative deadlock where a state would be unrepresented in the Senate for a period, and sometimes that period would be a full 2-year legislative session. California itself twice went a full 2 years with only one senator. Delaware went, I think, a total of 6 years. No,
So that's the
2
mischief.
years, 2 years
Yeah.
with no senators whatsoever. And
So that was the perceived mischief of the original mode of selecting the U.S. Senate.
and so how do you break a legislative deadlock?
Right. The original Constitution doesn't tell you how to do that. You just have to, the legislature has to figure it out.
And money, bribery was a way of doing that. Congress made matters worse. They passed a law. Congress has power to regulate the time, manner, and place of election, except for the place of electing senators. And so they came up with a time and manner of measure for electing senators. And so if a state had a senator who was to be elected or reelected, there would be a voice vote in each, in the first or second legislative day of the term. There would be a voice vote in both houses concerning the election of a senator. If no one was elected, now with that voice vote, everyone knew where the support was and how much, and who was voting how. If no one was elected, there was a requirement that at the beginning of every legislative day, the chambers meeting separately would have to cast a vote for senator. And this chewed up an enormous amount of legislative time. This is back when a state legislature met a month or 2 months at most per year, and often biennially. And so if the Congress has imposed this burden, consuming enormous amounts of legislative time to elect a senator, state legislatures wanted to get rid of that, what they didn't consider a power, but a burden. And yeah, and so that was quite the issue.
That's a pretty powerful motivation. You say in your conclusion, you go to Lincoln's Lyceum Address, 1838. That's how you begin your conclusion of the book. And you quote from that the wonderful language from Lincoln. Of course, this is before he was president, long before he was president, but he was such a wonderful speaker. He said that you say that in that Lyceum address, Abraham Lincoln worried, I'm quoting from you now, Abraham Lincoln worried that the founding principles of the Republic were fading from view. He said that he did not fear that they would ever be entirely forgotten, but that like everything else, now you're quoting Lincoln, they must fade upon the memory of the world and grow more and more dim by the lapse of time. I believe that's a quote from Lincoln. Nevertheless, this is you again. Lincoln warned that the consequences were profound. Those founding principles, he proclaimed, were a fortress of strength. This is now the quote from Lincoln. Were a fortress of strength. Those founding principles, he proclaimed, were a fortress of strength. But what invading foemen could never do, the silent artillery of time has done. The leveling of its walls, the silent artillery of time. So you're saying that Lincoln's word, I'm going to continue your quote. Lincoln's words perfectly describe the fate that has befallen the Constitution. The framers regarded the walls of constitutional structure as the remedy, the quote, remedy for the diseases most incident to Republican government, end quote. This is you again. They knew that Republican government was inherently problematic. And they devoted their efforts to designing constitutional structures that would rescue it from the opprobrium under which it had previously labored and make it worthy of the esteem and adoption of mankind. They succeeded so admirably that with the lapse of time, the problematic nature of Republican government faded from the people's memory, leaving them unaware of the peril of altering or abandoning the very constitutional structures that rendered our particular Republican institutions non-problematic in practice. The 17th Amendment was one such alteration. And that's so I wanted to ask you, you seem to think that federalism was a very good thing in the beginning, the original design of the Constitution, and the protection of the structural provisions, the protection of federalism, which was dominantly the mode of electing senators, not the Supreme Court coming in and striking down federal law. And it seems like when I read your book, it's not completely clear to me, but I think where I'm landing on your view on this, as you look at the whole thing, that now that the 17th Amendment is there, you have to kind of side with folks like Souter on some of this stuff, and just otherwise it's impermissible judicial activism. And you have to let the people make these laws. You have to let it play out. And is there some kind of hope that you have that people will see some kind of reductio ad absurdum and then go back and then take out the 17th Amendment? Is that kind of your hope? Is that how you're thinking of it?
Well, so the 17th Amendment is a symptom of
Yeah.
We could repeal the 17th Amendment today, and think of the senators that would be elected by the California state legislature.
Mm-hmm.
They would be even more radical than the ones we have right now. The repealing, the 17th Amendment is a symptom of the progressive embrace of simple democracy, not the complex mitigated democracy of the founding era. but simple majoritarian democracy that seems so attractive to so many today.
Mhm.
It's yeah. By the way, my use of Lincoln, when I said that Susan Ehrlich, that judge in Arizona, didn't like my original conclusion to the law review article, that's when I went in search of what would be a good conclusion, and that's when I found the Lyceum address.
Ah.
And yeah,
It really ties the book together because, well, you read the book and it just, it kind of sounds like you're, um, I, I'm not saying you're unclear at all. Actually, you're very clear in the book, but it just, the feeling you get that is that you're really profoundly bothered by some of these frankly Republican decisions by the Supreme Court. And so if someone was not reading it carefully, they might just assume that you're just that's just kind of how you stand on things, and that's your, you maybe you're like a senator. There's a senator from, oh gosh, Shel, I think Rhode Island. Anyway,
Whitestone.
yes, White House, Senator Whitehouse. He always calls it the Roberts Five, or the Rehnquist Five,
Yeah.
and but at the end, you're quoting Lincoln, and you have this wonderful language in there where it seems like it's just a tragedy. The American experiment is in a way heroic in some ways, but it's also kind of inevitably just dying. And I don't know if that's how you feel about it.
So I am very, very critical of the notion of judicial review.
Mhm.
Um, I tell my students I make one overtly political statement in my con law classes. And after that, I won't even mention who won the presidential election. And the overtly political statement I make is, I would much rather be governed by uh, Bill Clinton and the Democrats who controlled the Congress early in his term, Obama and the Democrats who controlled the Congress for a spell, then unelected judges appointed by Ronald Reagan. And I've told that to Scalia's face. And I say that,
I wish
because,
I could have seen his face.
and I say that because you can vote the rascals out, but you're nonetheless left with unelected judges who are free to overturn what the populace wants. And so
Yeah.
I'm very dubious of judicial review. I think Marshall got it completely wrong in Marbury against Madison. Not the syllogism that if a law is contrary to the Constitution, it's null and void. This law is contrary to the Constitution, therefore this law is null and void. I accept that. But the minor premise that this law is contrary to the Constitution was simply, in the case of Marbury against Madison, wrong. The court didn't expand the original jurisdiction of the court. It simply said, if you have original jurisdiction, this is one of the arrows in your quiver. You can use, you can issue writs of mandamus. So I'm very hesitant ever to embrace a Supreme Court decision striking down what the public, the elected representatives of the public have approved.
I see.
And so,
well, that would fit with how a lot of people feel about Roe versus Wade, where it was really Nixon's appointments. Well, it was at least one of Nixon's appointments. I think it was a couple actually.
Well,
Rehnquist was on the dissent, but
but
the but
both
Blackman was the one that
and
wrote it,
Berger went along with Berger.
And Berger did too. Yeah,
Uh,
and look at the disaster that's been for the last. That's been a real disaster,
yeah.
and that was all the Supreme Court, and you can't get rid of them. You can't. They're there, and that's all you can. Look at all the fuss that's caused. That makes sense to some degree, I guess.
So
Um,
when I was a grad student, uh, I had a very thick and full beard and mustache. And I turned conservatives off by how I looked and liberals off by what I said. And the 17th Amendment book is something like that. I've turned off a number of conservatives who really have liked the activist conclusions reached by the Rehnquist court, and turned off liberals by my embrace of the founding generation's principles and embrace of Lincoln.
so you don't have very many friends then. Well, how do you get to? How did you get to be friends with Scalia? I guess he was friends with Ginsburg, so but you're not Ginsburg, so
Yeah.
um,
Well, it was that
just
team.
writing a careful book on him was enough.
Uh, well, Scalia rolled with the punches.
Yeah,
He
yeah,
he didn't attach friendship to fidelity to particular
yeah.
outcomes.
He was
And the
old
truth
school that
is,
way.
in like 90% of the cases, Scalia and I would have agreed completely.
Gotcha. Uh, you mentioned Storing, Herbert Storing. It's not a name that maybe many people outside of certain circles know, but you mention him in your conclusion as well on page 283. And um, he was your mentor in graduate school, is that right? At the University of Chicago?
Yes. Herbert J. Storing uh, actually was a student of Leo Strauss at the U of Chicago, got his Ph.D. there, began in public administration. He wrote a dissertation in public administration under Leonard T. White, one of the biggest names in public administration in the first half of the 20th century. Storing then moved toward constitutional law. He wrote a number of brilliant essays. He began a massive project called The Complete Anti-Federalist. It was a 7-volume work bringing together the principal writings of those who opposed ratification of the Constitution. The first volume was, the subsequent volumes were edited materials from these anti-federalist writings. Volume 1 was entitled What the Anti-Federalists Were For, and he made the affirmative case for the anti-federalist. Herb Storing died at age 49 of his second massive heart attack. He was my dissertation. I was a research assistant for him on The Complete Anti-Federalist. And Storing wanted to have annotations to every reference to something in a footnote that the Anti-Federalists made. And for example, the Maryland farmer said, it has been either written or read, I can't remember which, that freedom is protected in the hands of frugal, industrious merchants. Well, Storing wanted me to find who might have said that. And this is before Google.
Wow.
One of my greatest finds was one anti-federalist writer said that Cardinal didnt said that he would rather lead mules than men into battle. And so I had to go through Cardinal didnt's 7 volumes of papers, of collected works, all written in 18th century French, and find where Cardinal didnt said that. Well, I couldn't find it. But I also had to find something from Abbe Mablet. And so I'm going through his 4 volumes of work, and I find that he says that Cardinal didnt says that he'd rather lead mules than men into battle. That was the greatest achievement I had in terms of providing a footnote for Storing. Storing was my dissertation advisor. I did a dissertation on James Wilson. James Wilson, born in Scotland, was educated to be a Presbyterian cleric, but before ordination decided to emigrate to the United States, studied law under John Dickinson, one of the great attorneys of the era, and became a classic Philadelphia lawyer, was one of the 6 people to sign both the Declaration of Independence and the Constitution, and ended up as one of the original members of the Supreme Court. He was the first law professor appointed after the founding, after the Constitution, and wrote a 3-volume work on lectures on his lectures on law offered there. And so I turned in a draft of the dissertation to Storing. It was probably 350 pages. And he suffered a heart attack, and he was in the hospital. And he read the dissertation and wrote about 90 pages of handwritten comment on the back pages of my dissertation.
Wow.
And it was a major revise.
Mm.
Anyway, got it done. The dissertation defense went well. He helped me get a big piece, a big article published on James Wilson. He was at the University of Chicago, got a chance to become take an endowed chair at the University of Virginia and head a center on the presidency. And he moved there in the summer of '77. Martin Diamond, another prominent American scholar,
Yes.
another student of Strauss,
Mhm.
testified before the Senate Judiciary Committee on preserving the Electoral College by Senator By from Indiana, was out to seek direct election of the president. Diamond testifies as he steps down after his testimony. He is struck by a massive heart attack and dies on the Senate floor, the chambers. Storing moves to Virginia, writes a big obituary for Martin Diamond, gives it to a colleague and says, "Read this, I'm going to go play handball," and suffers a massive heart attack and dies on the handball court. And so 2 of my great heroes died within a month of each other in the summer of '77.
That must have been devastating for you.
Yeah. Storing what one of my students, Gary McDowell, he was my student when I was at the University of Memphis, was admitted to the U of Chicago and was studying there, and followed Storing to Virginia. And so he leaves his home institution to go to this new place to be with his mentor Storing, and Storing dies before the fall term begins, leaving Gary in a bit of a lurch, but he ended up winning a Jefferson Fellowship and worked under another great con law guy by the name of Henry Abraham, and wrote a dissertation that the University of Chicago Press published under the title of The Supreme Court and the Equity Power. So he landed on his feet. But no, Storing was just.
What was he like as a person?
Storing was built like a middle linebacker. There was a 20-foot long oak.
Was he intimidating?
Pardon?
You mean he was intimidating
Well,
physically?
yes, and he would hit that table. We were all sitting around this big long oak table, and he would hit that table with his forefinger, and he'd make it bounce
With his finger?
You
Wow.
could, it didn't bounce, but it certainly vibrated. You could, if you were sitting at the other end of the table, you knew that table had been hit.
Wow.
And a very, a very.
Were you afraid? Were you afraid of him?
No. He was such a good teacher. He would assign readings, and I would get them. I would type out what I thought were the important passages and be ready in class.
Mhm.
And never what I thought was important did Storing emphasize or go to.
Hmm.
And it took me like 2 or 3 courses before I finally learned what was important. He also taught me how to write. And he taught me how to write because I read a rough draft of volume 1 of the Complete Anti-Federalist, what the Anti-Federalists were for. And I saw how he had, by pen, gone through and edited and smoothed out the argument, the language. And reading that was revelatory. I think he helped me become the writer that I am.
Wow. How well did you know Martin Diamond?
Much less.
Okay.
I was with him at some conferences, APSA, American Political Science Association annual meetings, but that was about the extent of it. I knew him more because of students of his who were at Claremont Graduate School when Diamond was in Claremont before he moved to Northern Illinois. Heard lots of stories about him. So I know him by secondhand.
Okay. When you just wanted to clarify a detail, did you say that Storing had made 90 pages of handwritten notes on the backs of your first draft of your PhD dissertation? Was
Yes.
that from the hospital that he did that?
Yes.
Wow, that's impressive.
Yeah.
And this is your dissertation at University of Chicago.
Yeah, on James Wilson.
You have such wonderful stories. I'm so grateful that you made yourself available to share your knowledge and your experience with us.
Well, it's been fun.
Yes, and you've prompted me to continue my thought about judicial review and the irony of constitutional democracy. And I think it's sometimes I feel like it's a never ending, like what Michael Ullman used to say, which is the American politics is the gift that keeps on giving. So,
Yes.
did you want to add anything else about Diamond or Storing?
Just one thing on Michael Ullman, that apparently at least $3 million has been raised to endow a chair in his honor.
Wow.
Yeah.
Wow. That's really wonderful. That's really wonderful. I'm glad to hear that. Uh, would you be willing to come back on at some point and talk about some of your other books?
Oh, absolutely. Yeah.
I'm almost done with your Indian gaming book, and I've read your books on Scalia and Thomas. So, and I want to squeeze all of the stories that you have, but, you know, but maybe before you retire. I don't know if you have the energy for that. You're retiring soon. Is that correct?
Probably in the next year.
Okay. All right.
Yeah.
Well,
I've been at it for 50 years. My wife pointed out to me, my first full-time teaching job was at Grinnell College. I was a visitor 1 year before I moved on to University of Memphis. Students that I had the year I taught at Grinnell, if they were freshmen when I taught them, they're 68 or 69. If they were seniors, they're 72 or 73. And
wow.
that that kind of floored me when I realized that, when she told me that. Yeah.
You're a workhorse.
Yeah. Well,
Yeah, and your books are they're well, for those listening, when you get the book, you'll see for yourself. There's a lot of detail. It's a lot of details that you've had command of in constitutional law. That's and it's ever growing. I don't know how you keep up with it, but what a wonderful opportunity that we have to have you on. And of course, you were my dissertation chair, and I really appreciate all the direction and encouragement and help that you gave me when I was.
well, you did quite a piece of work there on Kavanaugh.
I really appreciate the direction and advice helping me get through, especially with all the craziness. But we'll go ahead and let you go. We want to be respectful of your time.
Well, thank you so much for having me, and
Yeah,
I'm happy to come back at your convenience.
look forward to it.
Okay.
Happy Easter.